Hello friends, Namaskaram, Har Har Mahadev, Jai Shiv Shambhu. In today's class, I will discuss an important concern regarding Section 7 of PCA. This is a common query: how to contest, how to fight. So basically, there is no need to worry. Simply, we have to note down certain fundamentals so that whenever we are going to contest the case, we could easily put up our side before the competent court. Section 7 of PCA, inter alia, deal with public servant only. So if you are not a public servant, you're a private person, means a contractual labor. In that scenario, you could not be prosecuted as per Section 7 of PCA in isolation. So basically, whether you are a public servant or not, this is one of the most important counter check at the inception. In addition to this, we have to note down. Demand is sine qua non, means it is required to prove the case of Section 7 of PCA. In ample judgment, the legal principle has been settled. Mere recovery, mere acceptance is not sufficient. Demand is must. If there is no demand, the accused could not be convicted. But it is to be noted that every demand of money is not demand of bribe. Specific facts with corroboration, with consistency must be on record. And regarding this, you may peruse the judgment of Honorable Supreme Court. Title is Neeraj Datta versus State of NCT. Judgment date is 15th of December 2022. I want to clarify that in a PCA case, we are having a trouble of Section 20 of PCA. Because inter alia, it is providing a tool to the prosecution to prove your guilt. I want to clarify that the presumptions comes into motion at the stage of trial, but prior to trial, the presumptions could not be drawn. So when you are arguing your case on bail, there is no need to worry, the presumption would not be a hurdle. The prosecution is required to prove the case beyond the reasonable doubt. The prosecution is required to prove the existence of all the three factors: demand, acceptance, and recovery. If the elements are mismatched, inconsistent, or if they are absent, we could take the benefit. We are not supposed to throw our defense beyond reasonable doubt. We are supposed to prove our defense with the help of a theory that is called probable defense. We have to submit a plausible explanation so that we could create a doubt in the case of prosecution. For example, if the case rests on demand only, we may raise four important defenses. Number one, there is a mismatch in the report and the facts inter alia collected in the verification process. Number two, the electronic evidences are compromised. There is no compliance of judgment of Honorable Supreme Court, Ram Singh versus Colonel Ram Singh. Number three, there is violation of Section 63 of BSA along with Section 17A of PCA. And in addition to this, we could specify that the facts are compromised because there is no pendency over, there is no ill motive, there is no ulterior motive. And apart from that, whatever facts are submitted by the complainant are not counter verified, even inquired by the concerned ACB or by the vigilance. So on that count, we could take the benefit. But whenever they are having a case that there is recovery from us, in that scenario, again we are required to give the plausible explanation. But this time we have to rely on Section 119 of BSA. BSA means Bharatiya Sakshya Adhiniyam. Regarding recovery, we could specify that the money is not voluntarily accepted. It is thrown, it is grafted. The key formula is that we have to raise a plausible defense. We have to raise a probable defense. That is important and the key point. And apart from that, we have to check out whether the evidences are proper or not. If there is no further corroboration by the shadow witness, in that scenario, we could take the benefit. But I want to clarify that the phenomenon test is not the conclusive test to draw inference. It is basically a test to find out whether you accept it or not. If you accept it, inter alia, the test will be positive. If you not accept it, then test will be negative. But the test, whether positive or negative, could not be a conclusive factor to decide your guilt. In addition to this, from inception till end, the evidences, the statement must be in the consistency. If they are not consistent, there is lack of corroboration, we could get the benefit. And apart from that, the valid sanction order must be on record. It must be in the line of judgment of Supreme Court verdict. CBI vs. Ashok Kumar Agarwal, Apart from that, there must be indication on the file that there is application of mind. And apart from that, the sanction must not be mechanical. If it is mechanical, cyclostyle, indicating non-application of mind, we could take the benefit. For example, if the authority failed to verify whether work is pending with you or not, this is one of the most important points to chalk out that the authority has not applied the mind. Apart from that, in multiple cases, I have seen that they have not considered the electronic evidence while according the sanction. We could get the benefit also in our case if we are having the said circumstances. So we have to minutely examine our case at our own level and have to understand the same in the light of two basic principles. Number one, no authority could proceed in cyclostyle manner. If the authority are going to proceed in cyclostyle way, in mechanical way, we could challenge the proceeding. Number two, the demand is must. If there is no demand, mere acceptance, mere recovery cannot connect the accused with the crime. But to prove the demand, the facts must be certain, must be consistent. In addition to this, we may take the following point as our defense point. Number one, the work of the complainant is not pending and he submitted the false part. And regarding this, I request all of you to submit the memorandum because they are having the FIR, they are having the statement. What we are having, we are submitting our oral facts. Submit your facts in writing, that is called memorandum. So in the memorandum, you could specify that the FIR is false, report is false, there is no pendency of work. In addition to this, you may specify that the witnesses are not shadow witness or witnesses independent, rather than they are stock witness. And in addition to this, you may also put stigma on the credit of the complainant by putting him under tag the professional complainant. Because if complainant is in habit to lodge the false cases or multiple cases are against him, in that scenario, there is a possibility that he is acquainted with the process and this time he abused the process. In addition to this, the prosecution has to specify that the demand and acceptance is voluntarily, if any. If demand acceptance is not voluntary, and apart from that, there is no corroboration or consistency on that point, we could get the benefit. So we have to consider all this point while contesting a case as per section 7 of PCA. See you in the next video. Till then, Jai Hind, Jai Bharat.